Welcome to tonight's talk on restorative justice in the coronial setting. As you're aware, the Coroner's Court operates by way of a non-adversarial inquisitorial process aimed at discharging the statutory functions of the court, namely determining the cause and manner of a person's death and making recommendations that may improve systems following a death. Given the subject of an inquest is the loss of someone's life, often while in the care of someone else, the participants engaged in the coronial process are often grieving, traumatised and/or vulnerable people. This is true both of the deceased's family, but also those who may have contributed to the death and called as interested parties. Many of the clients of the lawyers that we deal with are health professionals or first responders, and in my experience, health professionals and first responders engaged in inadvertent but adverse outcomes for their patients and clients may themselves be traumatised by that experience. We're all aware of paramedics, nurses and other professional peoples who have been placed on workers' comp following an adverse event, and some never return to their professions. And the coronial process itself may be an enormous burden on their recovery and sometimes the straw that broke the camel's back. In saying that, it is acknowledged that the statutory function of the court often requires a robust investigative approach to fact-finding, which by its very nature causes stress to the participants. The court must perform its fact-finding role despite the stress that this causes. Nevertheless, the coronial process is ripe for active engagement of therapeutic processes that doesn't seek to necessarily pit the deceased's family against those who may have contributed to that loss of life. Healing and learning can be achieved through a corroborative and sensitive approach, respectful of the position of all participants. Tonight we ponder the role of restorative justice in the coronial process in this state. We are doing so by way of a panel discussion involving Joe Simpson and Sarah Woodlands, where I have posed some questions beforehand and have asked that they share their views having reflected on those questions. Joe was called to the bar in 2020. Prior to his call, Joe is a senior solicitor with the Aboriginal Legal Service. Joe has extensive experience working in a wide range of criminal, regulatory and commercial disputes. And through his criminal justice work in particular, Joe can share with us his experience of restorative practices in that jurisdiction, especially the practice of circular sentencing. Sarah was called to the bar in 2018. Prior to that, Sarah was a senior associate at Minter Ellison's. As a solicitor, Sarah had a broad commercial litigation practice, disputes practice. Since coming to the bar, she has focused on inquests and inquiries and health-related matters. She's appeared in inquest inquiries into the New South Wales Black Summer bushfires. There were 25 deaths, 41 fire inquiries sitting over 78 days, and the inquest into 2 deaths arising from the 2022 Yagara floods, as well as various inquests into deaths arising as a result of police operations. She's also acted for the Therapeutic Goods Administration, and Sarah is well published and sits on the New South Wales Bar Association Inquests and Inquiries Committee. It's probably appropriate to start discussion then with an understanding of what is restorative justice. Sarah, when we talk about restorative justice, what, in a theoretical sense, what are we talking about?
Well, thanks, Ben. Hello, everyone. The short answer to that question is there is no single definition of restorative justice. It's an approach to justice that emerged in the late 1970s in the criminal space. And it usually involved some form of mediation between victims on the one hand and offenders on the other, sometimes with their supporters as well, where they discussed the harm that was caused, how it happened, why it happened, and then they looked at ways that offenders might make amends. Now, over time, restorative justice has had a wider application beyond just the criminal justice system, and it's now being applied in some civil jurisdictions, civil disputes, also in things like bullying, workplace bullying, bullying in education institutions, sometimes wrongful imprisonment cases. So it's having a much broader application, and of course also in the Coroner's Court, which is why we're here tonight. Basically, it's a framework. If you think of it as a framework or a set of principles, the first being that, just turn it up. Oh, they're very small, aren't they? Very small principles. The first principle is that it's repairing harm. It's an approach to repairing harm caused by crime or death. That's the very first thing that we're addressing here. It's done through a flexible, inclusive, empathetic process. Now, it doesn't have to be a mediation. As it suggests, it's a flexible thing taking into account the event, the people that are involved. So the importance is that it's inclusive and it factors in everyone in the event. That flexibility and inclusivity recognises that not all parties will have the same response to a harm or a death. What may be therapeutic for some parties to an event may be re-traumatising and not therapeutic at all for another party. The process has to involve all parties, all stakeholders. So as I said, it's really broadened from the idea of just an offender and a victim. It's got to include all stakeholders, and that's really central to restorative justice. It's a recognition that a crime or a harm to a victim isn't just to the victim, but probably to the victim's family or broader community, and indeed the offender's family or community, and as well as third-party stakeholders, in a coronial matter, first responders, health professionals, police, social services, basically the ripple effect. And it really has to embrace all of those other parties as well to be part of restorative justice. Restorative justice principles have regard to social context. So it really is a matter of taking the parties as you find them. Now that might mean, in the case of a First Nations death in custody, for instance, that might mean that restorative justice principles would mean that you would approach the relationship between the family and the coroner through the context of perhaps experience of dispossession, or perhaps sometimes state violence or integrational trauma. So you take the party as you find them in their social context. Restorative justice has a preventative focus, and that's where it dovetails so well in the coronial jurisdiction. We're looking at ways to make amends for the harm, repair the harm, and part of that is looking to prevent it happening again in the future. So essentially, restorative justice is a framework that seeks to promote a more comprehensive, inclusive and satisfying, really, resolution of disputes between people. And that involves things like early engagement with parties, talking to them very early about how this problem might be resolved, clear and regular communication with parties, particularly about the process that's going to happen to them and any delays that might be happening, sharing of information, giving stakeholders all an opportunity to participate. They're all hallmarks of this process. So in short, we're trying to, in the coronial setting, we're trying to find out the manner and cause of death in a therapeutic way.
Joe, Sarah said the origins of therapeutic justice are found in the criminal justice system, and you have experience with that in circle sentencing. Could you just explain what is your experience in that jurisdiction in relation to restorative justice, probably by reference to circle sentencing?
Yes, I think I'll start by explaining what circle sentencing is. It may not be something that everyone is familiar with, but it's an intervention program that involves the modification of the local court's usual approach to sentencing. It allows eligible offenders to be sentenced via an alternative form of hearing that includes representatives from the offender's local Aboriginal community. So it's been around for a very long time. It started in smaller or regional locations amongst very tight-knit communities. communities, but has been gradually rolled out to metropolitan areas more recently. To explain how it works, the sentencing hearing takes place outside of the courtroom, so you might consider that to be a flexible approach. Where it takes place depends on the community itself. I've sat in a circle in a community hall, I've sat in a circle in the tea room of a courthouse, but they are informal environments that make for a naturally less formal process. The offender sits in a literal circle with the magistrate, police prosecutor, their legal representative, and the program facilitator, as well as at least 3 community representatives. The circle can, and in my experience, it often does, include the victim of the offence. Now that can be a particularly restorative aspect, because if the victim does participate, they're entitled to give their view about the offender and the nature of the offence that was committed against them. So it creates a direct dialogue between offender and victim. The victim is able to tell the offender what the consequences of the crime that has been committed have been for them, and it provides the offender with an opportunity to recognise that harm and to apologise. Now that's quite rare in the local court. People being sentenced for offences do not regularly give oral evidence, so it's uncommon for a victim to hear directly from an offender the words, "I am sorry," but that is available to them as part of the circle sentencing process. Now, the circle determines an appropriate treatment or rehabilitation plan and recommends a particular sentence. It is a recommendation only. The magistrate will only adopt that recommendation if they agree with the consensus position of the circle. Now, that is a constraint that maintains a balance between the restorative objectives of the program and the need to ensure that the legislated purposes of sentencing are met. But there are very considerable benefits to the whole process. One is educative. Community members get to raise issues and ask questions directly of the magistrate, and the answers will often explain the law or the policy behind the law in a way that informs those members of the community. It improves offender engagement with the sentencing process. The offender in that context is engaging with people who they have potentially known for their entire lives, or as someone who has the respect and admiration of their family and friends within their community. Now, that familiarity can lead to a better exchange of information. You hear a lot of things in the context of the circle sentencing that you wouldn't hear necessarily in court. That might be because your client or the offender is embarrassed, or because they didn't think it was relevant. But they can be things that are important to the overall sentencing process. Now, it obviously doesn't suit every offence or every offender, but in the right circumstances, it can significantly improve the outcomes for people involved in the process. Now, taking into account the principles of restorative justice that you've heard about, the circle sentencing process has many of those features. It involves the voluntary participation of the offender. It's inclusive of community representatives directly. It's focused on repairing the harm caused to the community and to the victim by criminal offending, and it emphasises a dialogue between the offender, community members and the victim that can facilitate victim satisfaction through a face-to-face meeting.
There is momentum to move towards a more restorative justice model in the coronial setting. Sarah, restorative justice is also sometimes known as therapeutic justice. In the current coronial jurisdiction, are there aspects of the process that are perhaps non-therapeutic for participants? And are we seeing the introduction of new practices and developments within the court that have perhaps a more therapeutic focus?
So there are definitely aspects of the coronial process that are non-therapeutic, and as much as everyone tries, I think some of them are inevitable. So firstly, delay is probably the number one thing that you hear about, is the biggest non-therapeutic aspect to the coronial jurisdiction. So the delay between the time of death and the end of an inquest and then the delivery of findings, as you probably all know only too well, it can be years and years, and in complex cases it can be 3, 4, 5 years. Or 6, I heard. Any takers on 6. So that can actually cause quite a lot of, that can be quite traumatic. It can cause a lot of fearful speculation from parties. They think, why is it taking so long? What does it mean? Something, there must be something going on in the background that I don't know about. It can lead to an erosion of trust. Parties, families think, well, what is the problem here? Is the coroner keeping things from us? What could possibly be taking so long? It can cause a suspension of grief. People can't move on in their grief journey, and it can actually really sort of stunt that process, which I don't think can be underestimated in these matters, and especially where the reason for the delay isn't communicated either frequently enough or with enough of an explanation. That can really be quite traumatic and tormenting, if you like. I know from my experience that the Coroner's Court does an excellent job of trying to keep parties, particularly families, in the loop for the reason for delays in investigations and things. And I think some of the delays are inevitable, and the court is hamstrung by funding. So look, I think that's a critical point, and that comes up in all the literature, and I think it's probably anyone who's worked in that jurisdiction understands that delay is a big part of the of a problem for the parties. The second one is something you hear a lot from families, and that is a lack of understanding or engagement in the coronial process. Now, I say this with some hesitation because the Coroner's Court, in my view, does an amazing job of providing a lot of support. They have the CISP program, the Coronial Information and Support Program, and through that they provide a whole lot of support to families and other parties who've been affected by a death. They have a forensic medicine social work service for the immediate impact of a sudden death. They have a lot of videos on the website about what you can expect when you go to court for a coronial hearing. But despite all of that, some families, and particularly ones that aren't legally represented, they still often have a lack of understanding about what to expect when they get there, particularly about the role and the function of the coroner. In my experience, they're really hoping for some sort of punitive outcome. They want to see sort of something happen that the coroner's not empowered to do. Families can also seem to, they have a perception, because they're not comfortable with the process, or they don't fully understand the process. They don't understand the formality, when to expect findings to be made, what the findings will achieve. Families sometimes report feeling excluded or isolated from the process, as if it's a process that's happening to them as opposed to being a participant. And again, look, I think the Coroner's Court and counsel assisting spend a lot of time trying to fill that gap, but inevitably when people aren't represented, there will always be a gap. And finally, the other main non-therapeutic part of the coroner's jurisdiction, I think, is just simply the emotional toll. I think, sitting in a CPD, it's very easy to sort of talk about it, but we're talking about sudden, violent, unnatural or unexpected deaths, and so there's unavoidably going to be trauma in unpacking those, and the fact-finding process that the coroner has to go through to satisfy their statutory duty. It's going to be emotional, and particularly for families, but also for other stakeholders, other interested parties, whether it be police officers in a police shooting, or a surgeon who's performed a failed surgical procedure, or somebody who's failed to resuscitate someone, there's obviously going to be the emotional toll there. And I think that, by and large, is handled very well by most people I see in court, by a very trauma-informed process that's really embedded in the court and all the decisions that are made.
There certainly seems to be a focus on those assisting the court to have a more trauma-informed process to the questioning, which is an evolving skill with those assisting the court.
Yeah, I think that's right.
There's also the introduction of the new practice notes, the First Nations and the Family Statement Protocols. Joe, in relation to the First Nations protocol, how or does that fit with a move perhaps towards a more restorative justice model in any way?
Yes, the commencement of the practice note addresses two of the major issues that Sarah's just outlined, and that relates to the delay involved in the proceedings, but also a potential for lack of understanding on the part of the family. The protocol's been around since April 2022, and it needs to be read in conjunction with practice note number 3. Both practice notes apply to section 23 deaths, so that is deaths that occur or are suspected to have occurred in custody or during a police operation. The point can be made that this protocol is directed towards providing for the experience of the family exclusively, where the concepts of restorative justice are capable of being extended to, perhaps should be extended to, all participants in the coronial process. So that may be an area for development in the future. But as I mentioned, there are two main focuses, in my understanding of the practice note. And the first is to address the potential for the adverse consequences for the family of the deceased where there's significant delay in finalising an investigation or conducting an inquest. And the second is to address the potential for adverse consequences where the family feels excluded from or does not understand the process and accordingly finds it difficult to meaningfully engage with the process, which could lead to feelings of them being shut out from the process and may have a counter-therapeutic result. The family is an obvious target for these therapeutic or restorative measures given the context in which they come to the coroner's court. And that's something that Sarah mentioned earlier as an aspect of restorative justice itself, which is taking people as they are. I might ask you to move the slides along there, Ben. I'm sorry. So just one more. So what's shown on the screen here are the objects of coronial practice note number 3. And you can see the highlighted portions there relate to a focus on providing families of the deceased with appropriate information and material on the status of the investigation and the coronial process in a timely and proper manner. And at C, a recognition that all coronial investigations and mandatory inquests into deaths of First Nations people are conducted in a culturally sensitive and appropriate manner. I'll just ask you to go one slide forward. The First Nations protocol itself includes a commitment from the coronial court that at each stage of the investigation, the court will seek to ensure that the work does not perpetuate cycles of grief and loss. Now, having regard to the objects and this statement of commitment, it's fairly obvious that the intention of the coroner's court today is to go beyond just determining the manner and cause of death, and rather to provide a therapeutic environment, or at least address the potential for adverse experiences. Now, to address the issue of delay, Practice Note 3 sets out a 5-stage approach to the process of a coronial investigation into a death in custody and establishes timeframes. That includes the preparation of a preliminary report into the death within 8 weeks, and a partial brief within 12 and a complete brief within 16 weeks. And to my understanding, significant efforts are made to comply with those timeframes where possible. Now, to foster the engagement of a family, there are a number of steps included in the protocol. The first, I think, which Sarah mentioned, is the allocation of an Aboriginal CISP officer as a liaison point for the family, and that's to occur as soon as possible or within 48 hours of a senior coroner determining that the court has jurisdiction. Those CISP positions are reserved for Aboriginal identified employees. My understanding is that there are 2 permanent roles that exist in court at the moment, but only one of those is filled. So it's obviously a position with a very significant workload. So the CISP officer will work with the family to identify cultural or ceremonial considerations around viewing the body and any proposed post-mortem examination and release of the body, as well as working to identify any issues that the family may wish to raise with the coronial investigation, including issues around the circumstances of death. The practice note also establishes an ongoing requirement for the exchange of information, sets an expectation that there will be contact between the liaison and the family at least once every 2 months for the purpose of providing an update in respect of the various stages defined by the practice note and providing the family with prompt notice of any delays in the investigation. The next matter covered by the practice note relates to family meetings. So there's an obligation that the senior coroner ensure that family representatives are offered an opportunity to engage in a family meeting, and that meeting is held with key people who are involved in the coronial investigation. And that is meant to take place within 2 weeks of service of the brief. Now, in speaking with a number of people in preparation for this talk, it's been impressed on me that these family meetings are often the most important step in fostering early and meaningful engagement by the family in the coronial process. Families can use these meetings as an opportunity to raise questions about the circumstances of the death and matters that they expect will be relevant to the fact-finding process that's going to be undertaken. I note that these meetings are often the subject of various protective orders which are designed to prevent the dissemination of any information that's exchanged. These meetings, I think, have a significance where a death has occurred in custody. Where a family is in a position where they're receiving partial, incomplete or potentially incorrect information from other sources, the issues that could be caused are relatively obvious. If a family has, for example, other connections with people inside a jail or a custodial environment, and they're receiving some information, but that's all they're receiving, it can generate a situation where that becomes the focus of their interest in the process. So these conferences can and are being used, as I understand it, to provide reliable information to families at an early stage of the proceedings. For example, if there's relevant CCTV footage that can dispel any incorrect assumptions or beliefs about the circumstances of the death, that can be shared with the family. Now, my past experience with the Aboriginal Legal Services informed this comment, but the experience of having a relative in custody can be relatively disorienting thing. It's not easy to have an accurate picture of what is going on in their lives, their mental or physical health, or even where they're located, as in which correctional centre they're located in. So where inmates are often moved, it can be sudden and the reasons may be unclear to them or the family. But in those circumstances, information about the circumstances of the death can be critical and is important to those involved in the process to manage their expectations and beliefs about what's going to follow in the coronial process.
So the other protocol is obviously the family statement protocol. How does that potentially fit with restorative justice principles?
So I'm not sure how many people here are familiar with the family statement protocol or what a family statement is. But for anyone who doesn't know, the state coroner issued the family statement protocol on 1 September 2025. And family statements are given, as the name suggests, by family members at the end of a coronial inquest after the evidence has completed. And the idea of them is that they're intended to give the coroner an insight into the lives of the deceased, of the family's loved ones, into their life, into their personality, something about their character, basically to bring the deceased back into focus in a informal way. Basically, this is what this person meant to us. You've finished with the evidence, you've finished with the witnesses, you've finished with your submissions, but this is the real person that this has all been about. And it's an optional process, and they may be delivered by the family members themselves, or if they think they can't, perhaps too emotional to do that, they will often ask counsel assisting. They'll prepare the statement and counsel assisting will read that out for them. And they may include multimedia. There may be videos or photos or music or what have you. The protocol that was issued in September last year sets out a guideline for what should and shouldn't be in those family statements. And specifically, it says that they're not a witness statement. They're not a victim impact statement. And therefore, the statements shouldn't contain new evidence. They shouldn't contain allegations of criminal or any other liability against any individuals or organisations. They shouldn't contain any critical or insulting comments, any defamatory statements about police or medical staff or other family members perhaps. And they shouldn't include any statements apportioning blame. So in terms of restorative justice, the protocol does two things. Firstly, it formally recognises the right of the family members to participate in the process. They then feel like this is actually part of their family's history rather than sitting back as onlookers. And secondly, the protocol attempts to afford protection to the rights and reputations of the parties, or the other parties to the process. Basically, the statement's not to be a free kick at the end of the proceedings when no one can respond. How is it operating in practice? Well, anecdotally, from my sort of survey and from what I've seen and spoken to other people, I'm not sure how many people are aware of the protocol. I'm not sure how widely it's being used. It is, after all, only a protocol. There's no formal consequence if it's breached. Some families will hear of it through their lawyer and they will comply with it. They'll provide a draft and it will be approved and they'll comply. Some families will hear of it and put it to one side and ignore it. Other families, particularly if they're not represented, they probably won't even hear of it. So it's really difficult to know how well that protocol is going to work. And it's also just inherently difficult to control what is said by families in these family statements without impinging on what's a really important moment for them. It's just a very sort of difficult balance. But an engaged coroner will manage families who ignore the protocol, in my experience, and they do it by firstly acknowledging the sentiments, particularly if there's anger or blame, that the coroner will acknowledge it, but in the same vein will say in open court that that's not evidence and it doesn't form part of the evidence or my fact finding. So that's, I think, one way that can be managed even if the protocol's breached. And for anyone here who is either counsel assisting or instructing counsel assisting, I would recommend making sure that families receive the protocol really early in the process, and that's going to improve the likelihood that they'll comply. If families receive it at the start of an inquest, I think the emotions are running too high and people aren't reading protocols. If they receive it the day or 2 days before they have to read their family statement, it's too late to actually have it approved. So the lesson is provide it earlier. And if you're acting for a party who may be exposed to some sort of damaging comments potentially in a family statement, my recommendation is to ask counsel assisting to confirm that the families have been provided with the protocol early in the piece. It's just one sort of safeguard that you can take. Is it foolproof? No, but it's just a step that you might make.
That brings us to some recent proposed legislative changes. Joe, Section 109 of the Coroner's Act mandated a review of the policy objectives of the Coroner's Act to check that they remain valid and whether the terms of the Act remain appropriate for securing its objectives. Has a review of that nature been initiated, and when was it initiated?
It has. It was initiated in 2014 in accordance with the requirements of Section 109 that it be conducted within 5 years of the commencement of the Act.
And when was it concluded?
It was concluded in 2024.
It was a prompt process.
So,
were there any recommendations arising from that review which would support a more therapeutic approach to inquests in the Coroner's Court?
yes, I think the short answer to that is yes. Probably worth observing that the review obviously took a long time to complete. There were periods of time and it was suspended so that other discrete reforms could be looked at and addressed. And it does pick up on and refer to other related reviews that have been conducted over that almost 10-year period that the review is ongoing. Probably most significantly is a review undertaken by the Legislative Council Select Committee, which handed down its report in April 2022. There's quite a lot of overlap, and in the course of this answer, I'm going to refer to both the statutory review but also the Select Committee's report. Ultimately, the review conducted found that the broader policy objectives of the Coroner's Court, the Coroner's Act, remained valid and did not need to be changed. But there are certainly aspects where a refresher of sorts was needed, and some of the changes are certainly connected with advancing restorative or therapeutic practice. Perhaps because of the length of the process, some recommendations are really formalisations of existing practices that are already undertaken in the court and that Sarah's referred to, driven often by the practice notes we've spoken about, but also just the initiatives of practitioners who are taking a more trauma-informed approach to their participation in the proceedings. So I suppose the expectation is that if these recommendations are legislated, then the expectation for a therapeutic or restorative approach to the coronial process may be more consistently applied. Practitioners can expect that there's going to be a greater emphasis on the matters we've discussed tonight moving forward. So I might just ask you to move to the next slide. So I'll make the comment that between the Select Committee report and the statutory review, the recommendations numbered in the hundreds, but we've made a short selection of 4 which address more directly the issues we're discussing tonight. But you can see recommendation 2 relates to an amendment to the objects clause of the Coroner's Act. As I said, the review concluded that the policy objectives were valid, but they did not reflect fully the modern coronial process. So you can see highlighted in the slide there a number of proposed inclusions that have a distinctive restorative justice flavour. At B, what's recommended is that the objects clause include a statement that the processes adopted by the coronial jurisdiction should be sensitive to and supportive of trauma and distress. At C, the processes adopted by the coronial jurisdiction should be cultural, safety and responsive and respectful of different beliefs and practices. And at F, a confirmation of something that, in my experience, is understood to be true, which is that the coronial jurisdiction should be inquisitorial in the way that the proceedings are conducted. The commentary within the report or the review itself recognised that these changes would better reflect the purpose of the Act and its principal objectives, to clarify its systemic focus, the therapeutic processes and practices, and provide important guidance as to its proper administration and interpretation. So I think it can be observed that what has previously been perhaps a more informal process is very likely to become a more formal process, and the development of these principles in accordance with those objects is a very likely thing that practitioners will have to face in the immediate future. Now, the next recommendation, recommendation 3, this is a relatively significant proposed reform, and it would affect a number of discretionary decisions that are made under the Coroners Act. Essentially, what it provides for are a number of mandatory considerations that anyone exercising those functions must take into account. And you can see there at A, before exercising any of those functions, what must be considered is that the death of a family member, friend or community member is distressing, and distressed persons may require referral for professional support or other support, which has an obvious therapeutic component to it. And at C, as we've been discussing throughout the course of this talk, that family members affected by death being investigated should, where appropriate, be kept informed of the particulars and progress of the investigation. And finally, recognition at F that unnecessarily lengthy or protracted coronial investigations may exacerbate the distress of family, friends and others affected by the death. Now, the purpose of this amendment, as I understand it, is that it provides a mechanism essentially for ensuring that the policy objectives of the Act are adhered to. Now, just moving to the next recommendation. So this is a recommendation provided by the Select Committee, and it will be familiar based on what we've been discussing. But the requirement is that the government develop and propose some reform options, whether they are legislative or otherwise, to ensure the provision of information and material to families in a timely manner in order to support their meaningful participation in investigations and inquests. Specifically, unless contrary orders are sought, all materials provided to the Coroner's Court of New South Wales should also be provided to the family or families concerned within 1 month of the brief being returned to the Coroner's Court through the Crown Solicitor's Office or the Department of Communities and Justice Legal. Now, in reaching this recommendation, the Select Committee received submissions from a number of families who've been part of the coronial process, and made the comment that their evidence highlighted how the coronial system to families can be complicated, confusing and emotionally challenging to navigate. These are all matters that practitioners are attempting in an informal way to respond to. There was also evidence heard by the Select Committee that the coronial system may provide a healing opportunity for families after a devastating loss. And a submission by the National Justice Project stated that the coronial jurisdiction has a unique role in investigating the circumstances that led to a death, and this can be the ultimate opportunity to provide truth, healing, closure and justice to families. And it was having heard that evidence and those submissions that this was the proposal that the Select Committee came to. Now, you might recognise that this is something that is already achieved to some extent as it relates to families of First Nations deceased through the application of the existing protocol. But what appears to be proposed here is a much broader reform that could have the effect of extending those practices to all families who are engaging with the coronial process. The fourth and final recommendation I want to refer to is also something that we have touched on previously, which is a proposal that there will be an increased allocation of funding to the First Nations workforce capacity at the Coroner's Court, including expansion of the ASIS Program Officer team and creation of other identified positions in the registry and other support positions. It's obvious that the intention of these reforms, and in particular this one, is to create an environment within which First Nations people are better able to engage with the coronial process. And so we expect that they will become more formal over time and be something that practitioners have to address and respond to.
These are obviously just recommendations at the moment. Sarah, in your experience, just on a practical level, have some of these recommendations informally been introduced into the court already?
Yes. So particularly things like the early engagement process. Just as a practical example, I was involved in an inquest where there were 2 deaths arising from the same circumstances, so 2 bereaved families. Neither of them were legally represented. One family was extremely enthusiastic is the wrong word, but very engaged in the coronial process, and had a lot of questions was proposing a lot of questions to counsel assisting, had a list of questions they wanted answers to, wanted to read expert reports. The other family was very sceptical about the value of the coronial. I mean, it was a mandatory process, but they were sceptical about the value for them as a family. They were reticent, they didn't really want to be involved. And in that case, counsel assisting met both families very, very early, more than a year out before the hearing, and went to their homes and sat with them and worked out, particularly in relation to the family that didn't want to be involved, tried to work out whether there was any benefit for them and what could be of value for them, exploring what they might want to achieve, if they could possibly achieve anything out of it, what they wanted answers to. They were obviously treated with great respect and dignity by counsel assisting, and as a result of that process, and the families actually got together every time they met with counsel assisting. The disengaged family would meet and they would talk about the meeting they'd had, and they would talk about, well, I think this is a good idea because X, or I'd like to know the answer to Y. And interestingly, the offline meetings that the family was having as a result of the meetings with counsel assisting brought this family together on a regular basis. It was only once every 6 months or once every 4 months, but they came together, and by the end of it, they were on board. They did want answers. They were asking questions. They did attend every day of the inquest, and they saw that counsel assisting was treating the circumstances of the deceased death with dignity and respect, and that they were being treated with sensitivity in a trauma-informed way, which Jo mentioned. And strangely enough, they ended up being, I guess, in a true sense of the restorative justice sense, they ended up being the restored family. They had whole family connections that they hadn't had before, had a lot of answers that they didn't ever expect to get answers to, and they ended up being really kind of fulfilled by the process. So that was an example, I think, of restorative justice in a way. It was quite unexpected. They came up to counsel assisting at the end, and they were really, really grateful for the opportunity. So it was a real turn of events. The second practical example that I was thinking of was came out of a death arising from a police shooting, and again, it was really important. Again, it's an example of having an early engagement with the family and finding out what was important to them, what bothered them, what bothered them most about the events that caused the death, and keeping in mind the families are only going to have the barest slice of the facts. So they may be terribly troubled about something, and actually once they find out the other slice of the pie, the factual pie, the penny drops. So if you find out what it is that they're wanting answers to, what's troubling them as far as they're aware. In this case, they were really troubled about the way police behaved and the shooting. So that led to counsel assisting's questioning having really an educative dimension. Counsel assisting tailored the questions so that the questions asked of the police officer were educative, both to the coroner but also to the family. And as some of you may well know, police officers have extensive training in dynamic situations, and none of that training is apparent when you're looking at, say, a video of a police shooting that's happened in the line of duty and for good cause. None of those decision-making, that training process is apparent until you hear it from the officer's mouth in the inquest setting. And in that case, the family really, I mean, there is a real softening when people go into an inquest and hear a police officer who is obviously traumatised by an event like that, and the family gets to see that the police officer has been affected and badly affected. And that really does change the families, often changes the position of the family or the feelings the family has, and it certainly did in that case. The family could see that the police officer was very affected, and it wasn't the outcome the police wanted either, and it was impactful. So that's the other example I can think of recently that you can see restorative justice principles at play in an informal way.
You talked about the traumatised police officer in that answer, and I know people in this room act for first responders who are often traumatised witnesses who may not themselves find it very therapeutic to be giving that evidence, even though it's for the benefit of the family. Were any of the recommendations that Joe discussed or you've seen in the process of looking for this talk dealing with things such as the buy-in or the involvement of other stakeholders apart from the family in relation to playing a truly restorative model in the coroner's court?
I think the short answer to that is no, which is an unfortunate aspect of the review. The focus of all the recommendations appears to be on making it a therapeutic process for the family primarily.
That's the emphasis for sure.
And there might be reasons why they're an obvious target for that, but it doesn't mean that they're the only participants in the process who would benefit from a therapeutic approach.
In my experience, just anecdotally, I don't know if others have seen this, but of late I have seen counsel assisting more willing early on in an investigation to reach out to interested parties. I have seen them have meetings at an early stage where they've said, can we have a lawyer or meeting to try and work out what the true issues are. I find that a really positive process because it gives, in my experience, whatever it's worth, often traumatized first responders who have to give evidence, or don't have to be traumatized, very upset or stressed first responders, find the whole process quite removed from them. They see they put on a statement 2 years earlier, then the next thing they know they're in court. The family are working with counsel assisting, which is entirely appropriate, but they feel a little removed and threatened by the process. But in fact, they have information that would probably assist the healing process and decrease their stress if it was able to be communicated in an effective way. And I find those, whatever it's worth, those informal discussions with counsel assisting at an early stage helpful, because it allows you to say we've spoken to counsel assisting so that your clients, if you happen to be acting registered parties, have a buy-in to the process, and you can potentially share information in a way that decreases the stress on them, but also gives answers to the family so that it's not left for 2 or 3 years later when someone's feeling excluded. And I think it's an important thing. And in fact, I've had one recently where we reached out. So we received a whole series of, I won't talk about the matter, but we received a whole series of requisitions that implied that there was a racial bias in that care was provided, and we could not see that. It seemed to be the focus though, of a lot of these requisitions, and so we've made a constructive approach because that has a lot of cultural loading to our own staff and to people who have to give evidence, and we want to deal with that in a proactive way. So one, we can reassure the family as best we can, that's not relevant, and two, it helps our own staff avoid the trauma of having to address those sorts of issues if they're not really relevant. It may not be successful, but I think we've reached out and hopefully we can help define issues. And I think I'm seeing that those assisting the court are more willing to engage in a corroborative process, which should help the family, who is the true focus of the trauma, but also decrease the trauma on other stakeholders, which is good. The other issue, Joe, is Section 61 of the Act. Obviously, if we were to have circle sentencing, we're not talking about victims and perpetrators of coronial law, it's very different. But if we were to have earlier engagement directly between parties, how would that operate with Section 61?
I think the only way to answer that is to say that Section 61 will remain something that practitioners need to consider carefully in representing any interested party in a coronial process. The changes that have been proposed by the statutory review are all directed at a relatively general level. But what you might expect is that where an obvious component of the changes appears to be to promote family participation in the process and the early disclosure of information, there'll be an increased focus commensurate to that in facilitating the information is provided by other interested parties. So it's likely to be something that practitioners need to consider potentially earlier, but at this stage it's very difficult to say how exactly those recommendations will be implemented and how that could affect practitioners dealing with an issue under Section 61, except to say that the vibe of the changes is very much that there'll be an expectation for early disclosure of statements.
I think we've pondered restorative justice this evening in this setting. Does anyone have any questions? I know we've got a few seconds left. No. Well, it's 6:28, and then we have drinks. No, thank you very much for joining us. I hope you found that informative, and certainly it's an area that I think is going to evolve. And for those of us who practice in the area, it's certainly something that we should be alive to as the court deals more with restorative practices. So thanks very much.
Thank you. Thanks.